6 low traffic neighbourhood schemes implemented by Croydon Council have been deemed unlawful. Why? Because the High Court ruled that their dominant purpose wasn't health and safety, but was actually to make money. Let's talk about it. Hello, my name's Ryan, I'm the Code Legal Lawyer, and I give a legal view on the latest news. Don't forget to check out our website, codelegal.co.uk, where we're currently offering free consultations for anyone seeking formal legal advice. Now, what do we think about low traffic neighbourhood schemes? Although they've been around since the 1970s, there was a significant push for these in the 2020s and onwards, and we're all familiar with examples of these schemes, including things like AMPRs, bollards, planters, one-way traffic systems. According to TfL, they reduce road danger, they reduce traffic, they increase healthier methods of travel, such as cycling and walking, and they improve the air quality around us. Opponents of LTNs state that they just shift traffic from one area to another. They increase journey times, delay emergency vehicle access, and they negatively affect local businesses due to this reduced vehicular access. Now, the legal framework for LTNs is found in Section 122 of the Road Traffic Act 1984, which grants their purposes to secure the expeditious, convenient and safe movement of vehicular and other traffic. And this is further expanded upon in subsection 2, which includes the desirability of securing and maintaining reasonable access to premises, the effect on amenities, the national air quality, etc., etc. None of these reasons include generating revenue, however. The case between Karen Lawrence and the London Borough of Croydon stems from 6 LTN schemes that were trialled on a permanent basis in 2020, but which were made permanent in March 2024. In essence, the schemes closed certain roads which were enforced by AMPR cameras. Karen Lawrence was concerned by these schemes and formed the local pressure group Open Our Roads. She contended that Croydon had exercised its statutory powers for an unlawful purpose, which was to raise revenue, and that they'd failed to review the impact of the schemes in accordance with their statutory obligations. Croydon Council obviously denied this, and the evidence in this case was quite interesting. In December 2020, Croydon Council's Director of Finance issued a notice confirming that it could not balance its books and projected an actual income shortfall of £67 million for the 2020-2021 financial year. In March 2021, Croydon Council approved a budget that included a projected income from traffic camera enforcement of £11.6 million. And at a meeting in November 2021, the Chief Financial Officer stressed that if the traffic schemes were not delivered, then it would impact the council's ability to deliver its services within budget. Now, the impact report for these schemes was quite mixed. Whilst road traffic decreased in some areas, they actually increased in others. And with respect to air quality, it was slightly reduced within the schemes, but increased on roads outside of the schemes. Now, this is the kicker. The Conservative councillor, Jason Perry, who was a vocal critic of the schemes before and after he became the mayor, stated he wanted to remove them, but he did not think it was possible because the previous administration had predicated their budget on assumed income from the schemes, and that's what sealed the deal. The judge, Mr. Justice Pepperell, stated, taking the relatively modest benefits of the schemes into account, together with the mayor's apparent lack of public enthusiasm for the road safety or health case for these schemes, and his clear and repeated comments before and after the vote as to his hands being tied by the budgetary considerations, I am satisfied on a balance of probabilities that the dominant purpose for these orders making the schemes permanent was the need to safeguard the revenue raised by enforcement. Such purpose was unlawful, and I therefore quash the orders. So there you have it. Where the so-called benefits of these LTNs are modest and the council seem to be strongly relying on the assumed budget bought by these schemes, they may be deemed unlawful. And this isn't the first time that LTNs have been deemed unlawful, such as with Lambeth Council, who failed to take into consideration the impact of excess traffic on already congested roads. So if you're a local resident who's concerned that some of these measures may just be revenue generating exercises in disguise, there is scope to successfully challenge these orders. So what do you think about this and the mass introduction of LTNs in our cities? Are they for our health and safety, or are they just a further means of extracting cash from the public? Let me know what you think in the comments. Like, share, subscribe. Thanks for watching.